Did you know there is a situation where the Supreme Court would have to use a jury? First, we need to understand when a jury is required under United States law. The Sixth Amendment to the U.S. Constitution states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury." This guarantees a defendant the right to a jury trial in a criminal case. Additionally, the Seventh Amendment states, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. This amendment was adopted in 1791. Therefore, the common law referred to in this amendment has been interpreted as meaning the common law of England in 1791, which the U.S. based its judicial system on. Therefore, this amendment guarantees the right to a jury in a civil case, which seeks monetary damages more than $20, so long as the case, or a similar case, would have triggered a jury trial under English law in 1791. These are the only cases where a jury is required. Therefore, the question becomes, could the Supreme Court hear a criminal case or a civil case seeking monetary damages? The answer is yes. Article 3, Section 2 of the U.S. Constitution states, "In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction." Therefore, consider a situation where two states sue each other for monetary damages. Under Article 3, Section 2, this case would fall under the Supreme Court's exclusive jurisdiction, so they would be the ones to try the case. Additionally, as the states are suing each other, this would be a civil case seeking monetary damages. Therefore, the Seventh Amendment would apply, and the Supreme Court would have to hold a jury trial to try the case. In American history, the Supreme Court has actually held 3 jury trials. However, the last one was in 1797. Therefore, how has the Supreme Court been able to avoid holding a jury trial for over 2 centuries? There are a couple of reasons. The first is that the 11th Amendment, ratified in 1795, protected states from being sued by individuals. This removed the easiest way to trigger a Supreme Court jury trial. The second is that the Judiciary Act of 1925 gave the Supreme Court the option to refuse to hear cases. This act was passed to reduce the number of appeals the Supreme Court had to hear, which was becoming unmanageable. However, the act also allowed the court to refuse to hear cases over which it had exclusive jurisdiction, such as suits between states. For example, in 1981, the San Diego State and West Virginia football teams had a contract to play 2 college football games. West Virginia allegedly broke off the contract, leading to California suing West Virginia for breach of contract. As a case between 2 states, the case fell in the Supreme Court's jurisdiction. However, the Supreme Court refused to hear the case. If they had heard it, it likely would have required a jury trial under the Seventh Amendment. What do you think would happen if 2 states sued each other over something more substantial? Do you think the Supreme Court would hold a jury trial?